Thank you, Your Honor. Daniel Woodring here representing Bridlewood Group Home, and I would like to reserve 5 minutes for rebuttal if I may.
Okay, you may.
May it please the Court, we're here today because the Agency for Persons with Disabilities rejected an administrative law judge's recommended order finding there was no basis to revoke a group home license, and instead of following that order, revoked a group home license. That had the effect of displacing the developmentally disabled individuals that were in that group home and affecting Ms. Tomlinson, who ran the group homes, her livelihood as well. Respectfully, APD had no basis to have taken action against this group home license. The circumstances very shortly, and there were 2 counts in the complaint they brought, but only 1 count is still at issue. The circumstances very shortly were that an employee of the group home was involved in a sexual assault against one of the residents of the group home, which is a very sad situation. However, under the law, before you can have liability for that as far as the group home, there has to be some negligence, some responsibility on the part of the group home when you have an employee that commits what's otherwise a criminal act. After a full hearing, the administrative law judge found that there was no basis for any liability. They had done the appropriate background checks. Nothing showed up. They had the appropriate training. They had the appropriate staffing. After the incident occurred, it was reported immediately to law enforcement, and so he basically found there was nothing that they could have done any differently.
Unfortunately, it's what they did in the aftermath that probably looks the worst. Efforts to persuade the victim not to prosecute and things of that nature. They look better on the front end than they did on the back end, and I don't know that that should factor into any of this, but I'm certain that's what's, given the agency difficulties with, not doing anything about this.
Well, Your Honor, that may be, but even if we look at what happened on the back end, and I would tend to agree with you as far as if you look at what they charged in the administrative complaint, and remember, in a licensing case, they have to prove by clear and convincing evidence the specific grounds in the administrative complaint. So I think when you're actually looking at the back end of this, I don't think you're even under the administrative complaint anymore. But assuming we were to look at that, I think the agency has made a grave mistake in this, in that we have the testimony of the developmentally disabled individual, and there is some testimony where she's saying that I was told to forgive and forget, and there is that conversation in there. However, contrary to the agency's representation to this court, that testimony is not uncontroverted, because Ms. Tomlinson, and it's at record volume 5, and it's let me see the page on that. It's cited in the brief there, page 351 to 352. Ms. Tomlinson was asked the question of, and did you ever instruct or promise anything or threaten in any way the victim to drop the charges or not to pursue the charges against LaSalle Saunders? Ms. Tomlinson: at no point I instructed her not to. I was very cooperative. I wanted something to be done at the time. I wanted something bad to happen to him. And I felt betrayed, and I felt for my consumer. So whatever the law is, and I kept asking APD to do something. There should be a disciplinary action to employees. Something like that. So I would not have asked her to do anything differently because that was not in my thought process. So even as to what happened at the back end, the evidence is not uncontroverted as to what happened at the back end, unlike what the agency represented. But I think the main point we're making, though, is, okay, what happened here in this case is initially they get the recommended order, and it says, I find no basis to revoke this license. In the agency final order, they come up with this theory that, well, yeah, we can't change most of the things in the recommended order, but we're going to say that because it has to do with the credibility of a witness with developmental disabilities, that the ALJ is incompetent.
Was there anything in the record to prove the incompetency of the ALJ, or is that just an assumption made by the agency?
I think it was a complete assumption. In fact, I'm not sure if it's clear on this record, but there's the inside baseball. The ALJ in this case is
They
ALJ
referred the
Newton.
matter to that particular ALJ?
Right. The ALJ Newton in this case, just kind of as a trivia, is the former counsel for the Agency for Persons with Disabilities for about 3 or 4 years, if I'm not mistaken. So there was, you could argue if there was a special sauce, he must have had it, but there was nothing in the record that said he was incompetent. Of course, as we also made the point, in most cases, you have to weigh the testimony of a witness. So if you have a witness that has a developmental disability and one that doesn't, APD says their expertise is the one that does. So they couldn't even weigh those two witnesses. But it's just a completely, there's no case law they cite in support of it. It's completely out of left field.
The ALJ recommending no sanctions, no revocation, complete denial. It's not a matter of the penalties being increased by the agency.
No, that's correct, Your Honor. They cited in their answer brief that they had increased the penalty.
Right, that's where I'm going with that.
Right.
It didn't make sense to me.
And I don't see how you can argue that's an increased penalty. Usually an increased penalty is you find that there's a violation and there's a recommended suspension or something, and then it's changed, and it is true agencies have some discretion in that. But in a situation where there's no finding and the penalty is no, I guess you could technically say that it should be revoked is an increase from a don't revoke, but it's not under the, that's just a ridiculous understanding of what increasing a penalty would be. So again, I think this is actually, it's a fairly easy case. It's very unfortunate we have to be here because even with the relief this court can give, it will never make the Bridlewood group home and the folks that were there in that home whole, because the consequence of this case is the license was revoked, those were all displaced, and so even if the license is restored and there's another application for a license for a home, obviously we lose that whole time. So for whatever reason, APD definitely appeared to have a reason that they were going after this license. Unfortunately, the facts and the law did not support them, and there's just no basis they had. They clearly did what they're not allowed to do with a recommended order. If there's any way they could have ignored the findings without having a basis to do it, they did it. And the sad thing is that since they've done it, they continue to try to argue for all the rationale to do it. And they've now come back and said, well, there was no CSE, which of course the final order never found there was no CSE. So even if we were looking at that, if you look at the record, there is competent substantial evidence that supports it. Then, they finally said, well, it's...
That would send it back for another hearing, wouldn't it?
Well, actually, you don't have, under a situation here, if there had been no competent substantial evidence in the record to support the ALJ, the agency final order could have said that. It wouldn't have to go back for another hearing, but that wasn't the circumstance here. Then, of course, on the uncontroverted, we spent a lot of time talking about that testimony, as you said, about what happened after the fact. And they make the whole point that, well, you can't reject uncontroverted testimony. Well, I think the law is clear that you can, because you can have a witness who testifies and a hearing officer can determine, or an ALJ or a jury maybe can determine that they don't find that witness credible. That may be the only witness on a point it can be rejected. But that was really a side point, because that's the thing that I think is worse, is they spend all this time talking about uncontroverted evidence, and there's the record we just read that shows that Ms. Tomlinson is denying that she ever told the client not to press charges. She's saying she never did that. So, I would be...
So then, remind me, what's the evidentiary base for that then? Because those allegations have been made.
Those allegations have been made, and the evidentiary basis for that is there was testimony from LW, who was the developmentally disabled individual, that Ms. Tomlinson had told her about forgiving and forgetting, and that she then told the state attorney that she didn't want to pursue the charges. But what we don't know is we got to remember a few things. First of all, this is someone that has a developmental disability. I don't know, for example, the mental age we're talking about here.
But that's the only, as I recall, that was the only source. There was nobody that heard the conversation, or there was no other person who testified to it.
That's correct. The only other things in the record they cite to are basically interview records of when she was telling the investigator or the state attorney that same thing. So it's kind of you could call it the hearsay records coming in as to what she said. But no, that is the only evidence in the record. And, we don't know.
So forgive and forget can be a whole lot of things. It may have just been a therapeutic way to get the victim to be at peace with the whole thing, and may not have been an effort to persuade her not to press charges. Is that possible?
I think it is, because I mean, there's the formal judicial process, and then there's the personal, what you have to do to move beyond something and go on. So, I mean, we don't know for sure, but the point is that the only evidence in the record is, as you said, and it's clear that evidence is not uncontroverted, because Ms. Tomlinson said, and she reported this case. She took her to the state attorney. There's no evidence that at any time, I mean, her testimony is that, she wanted something to be done. I felt betrayed. I wanted something to be done. She's been working with developmentally disabled folks in this home since 2006. So this is not a new enterprise. She's been doing this for a while. She's a pediatric nurse in the other half of her life. So there's just there's no evidence to support what's being talked about here, and it's clearly not uncontroverted. So given that, I mean, we would respectfully ask that this court reverse the final order and require that the license be reinstated. And if there are no further questions, that's all I have. Thank you.
All right, you got your rebuttal time reserved.
My apologies, Your Honor. I'm attempting to locate the specific provision in the transcript that opposing counsel was referring to.
Well, you've got 20 minutes. You can use it any way you want.
Thank you, Your Honor. My apologies. May it please the court, my name is Jonathan Grab, and I'm representing the Agency for Persons with Disabilities, which is the appellee in this case. It is the agency's position that this court should affirm its final order, which evoked the appellant's group home license based on the undisputed testimony of Police Detective Napolitano and the undisputed testimony of L.W., the vulnerable adult victim in the present case, who possessed a developmental disability and was sexually assaulted by one of the appellant's employees, as described in count 1 of the agency's administrative complaint.
Can you outline what you feel the licensee did or failed to do leading up to the time of the incident that you're critical of?
As acknowledged by opposing counsel moments ago, it's less about what the opposing counsel did leading up to the incident and more about what they did following the incident.
Is there anything at all leading up to the incident that you take issue with?
There is not anything in the record that we take issue with regarding what led up to the incident.
As far as the hiring of the individual, the training of the individual, the instructing of the individual, there's nothing there to find fault with. Is that right?
Not that is on the record that we are aware of,
Well, that's
Your
all
Honor.
we have, is the record.
Yes, Your Honor, and that's why I refer back to it is what they did immediately following the incident, which I do believe is relevant to the administrative complaint. Now, opposing counsel has decided to, I believe it's Cottrell, is one of the cases to suggest that this was not effectively pled in the agency's administrative complaint.
But wouldn't our big concern be with preventing these types of incidents, and shouldn't that be the focus of this whole thing? And if you agree that everything that they did up to the incident was appropriate, then there's nothing more they could have done to prevent the incident. Is that a fair statement?
To prevent this specific incident, but the problem comes in that by discouraging the prosecution of this employee and convincing
But didn't they call the police in the first place?
That was the testimony, I believe, of the appellant, yes.
Is there any dispute to that? I mean, the police obviously got involved somehow.
Not on the record.
Okay. Okay, well, from our record, that appears that's the only way the police got involved. And then I guess after they were involved, there is some concern about things that were said. And we talked about some of them, but we didn't mention the fact that, once law enforcement arrived, the licensee began discrediting the victim's allegations and basically saying that, she exaggerated things and that she may have dressed inappropriately and all sorts of things that, aren't a good thing to say, but she apparently did say those things, and that appears to be uncontroverted as well. Is that right?
Yes, Your Honor, to the best of my knowledge, and that is part of why I wanted to find the specific transcript provision that opposing counsel referred to. If I remember correctly, that provision actually referred to a question where the appellant was asked, more generally, did you believe LW when she came to you and basically made these allegations? Not necessarily that LW, or not necessarily to address specifically had she discouraged LW from pressing charges. Now, that being said, I apologize. That is just from my memory. That's why I was trying to locate that particular provision in the transcript.
So was the revocation based upon the conduct before this aftermath occurred?
No, Your Honor. In this case,
I'm about to clarify that
it was based on the support and guidance that was provided to LW immediately following the incident.
Okay, because
the overruling, the revocation was based entirely on after the fact
and
interpretations of what happened. Is that you've agreed to that, right?
To some extent, but I would qualify that, Your Honor. I would note that the reason the agency is so concerned about what happened afterwards is because this incident now has put the resident as well as other residents of facilities in a dangerous position. And the reason I say that is that the only way that a provider or licensee would know that this individual has sexually assaulted a person with a developmental disability, a vulnerable adult, would be if that person had a disqualifying criminal offense. By telling LW that she should forgive him and convincing LW to not press charges, and specifically LW's quote was, she was told to tell them to forgive Garfield. And when the court people asked me, what if he do it to somebody else, I just to forgive him, like she told me to tell him.
Well, it's kind of like the new offense that you're talking about now. The cover-up. Let's call it the cover-up. Okay? I believe that they cited case law that said the revocation has to be based upon active misconduct at the time leading up to the event. And you're now saying it can be based upon active inappropriate conduct after the fact.
And
that wasn't what was in the count in question. Was that part of the allegations in the count that served the basis for the revocation of the license?
Respectfully, Your Honor, I would disagree with that contention. Cottrell, which I believe is the case
I
that
want to see what you have to say.
Sorry, what?
That was their contention, as I understood the brief.
Correct, Your Honor. I believe that is their contention. However, Cottrell does not necessarily say about when in proximity to the incident alleged the conduct has to refer. It just says that the conduct must be alleged in the agency's administrative complaint. Here,
all these things were in the complaint, you're saying?
Sufficiently alleged to provide the agency with its case. And the reason I say that is that even taking their position and saying that the agency should have alleged it with more specificity, at hearing, opposing counsel had no problem providing evidence regarding the appellant's conduct following the investigation, during the investigation, and actually planned for that testimony to be presented. So to the extent that there was any error purportedly in the administrative complaint, obviously opposing counsel had already presumed that those issues were going to be in dispute during the administrative hearing process. So to the extent that opposing counsel now say, oh, well, this wasn't pled with sufficient specificity for us to know what to argue, they did know exactly what to argue. As such, I would suggest that, if that were error even, that it would be harmless error at best.
That was ignored by the administrative law judge, the aftermath?
It wasn't completely ignored, and that's part of the agency's contention, is that the administrative law judge did discuss, and I believe it's paragraphs 7 through 12 of the recommended order, go into what the appellant did following the sexual assault of the vulnerable.
He said it was
adult.
irrelevant.
And, pardon?
Did the administrative law judge say it was irrelevant?
Not to my knowledge regarding those incidents following the following the incident. And that's why I believe that those issues are important to the court's decision. If the administrative law judge did not believe that those issues were relevant, why did he discuss them in paragraphs 7 through 12 of the administrative complaint, the recommended order? Now, that being said, despite having a discussion of all of the things that the appellant presented and other witness testimony following that incident, the administrative law judge made absolutely no reference to any of the testimony provided by LW, did not make any determination of LW's credibility, did not make any reference to the testimony of Detective Napolitano, did not reference any of his testimony. There is nothing in the record to suggest that the administrative law judge even considered the testimony or judged their credibility in any way. And that's, I think, where the problem lies, is that because the administrative law judge failed to make any findings based on that testimony, that's where the error on the administrative law judge's part came in. And then the agency, pursuant to Section 120.571L, has the authority to modify those facts because they're not supported by competent substantial evidence.
The agency appears to have taken the position that the administrative law judge was incapable of determining the credibility of the victim who has a developmental disability, because that is a matter that exclusively the agency is qualified to do as opposed to the administrative law judge. Have I said that correctly? Do you agree with that?
No, Your Honor. To the extent that could be read from the agency's final order, the agency does not believe that it has the sole ability to judge the credibility of a person with a developmental disability. Here, frankly, what really is the issue is...
Judges all over the state now would be in a situation if the position is that a judge is not capable of addressing that in a person who's developmentally disabled, and that only your agency is, that would be a real concern. That's why I want to make sure I understood that.
And Your Honor, I would agree with that. And that's why I would note really the issue is not that the judge didn't have the ability to judge the credibility of these witnesses. It's that, frankly, he made no effort to. There was not even an attempt to determine their credibility during the hearing. I would just like to reference also, opposing counsel has cited White versus, and I apologize, it's White versus something management company. Just a moment. White versus Bass Pro Outdoor World. My apologies. For the contention that an administrative law judge may reject uncontroverted testimony. Now, even if that's true, here, that is not what the administrative law judge did. He didn't even review the credibility of these witnesses. So for one, it could be distinguished from White. Second, the first DCA, which issued White, then 2 years later issued its opinion in Marsaki, which was cited in the agency's answer brief. As noted in Marsaki, quite to the contrary, it seems that the first DCA stepped back from its opinion in White and actually noted that when an administrative law judge made a ruling that rejected the uncontroverted testimony of a witness, in fact, that was not supported by competent substantial evidence, and that those findings actually warranted reversal on appeal. So frankly, to the extent that opposing counsel suggests that White is controlling on this case, one, it can be distinguished because at least in White the credibility of the witnesses was addressed, and second, even if White were relevant to this case, The later opinion in Marsaki suggests that white may not actually be a good law anymore. Your Honors, I think really the agency's concern in this case, and to reiterate, is that the testimony of LW and the testimony of Detective Napolitano was not even addressed by the hearing officer. Now, opposing counsel, I believe, noted in their argument that, frankly, if these actions by the ALJ were not done based upon competent substantial evidence on the record, which Marsaki suggests is the case here, then the agency has the authority pursuant to Section 120.571L to modify those findings. Here, that is what the agency did. In its exceptions, the agency specifically addressed which paragraphs it believes are in dispute and are not supported. And in its final order, it addresses those and notes that there was a review of the entire record completed. Another point noted by opposing counsel.
Can I just interrupt you, because you were making some statements about the revocation being based upon the aftermath, and I'm just having trouble finding that documented in this record. And I'm going to refer to the administrative law judge, paragraph 39, where the law judge says the agency sought revocation for violation of section chapter 393.06731B, which says that the agency may revoke a license if the DCF verifies that the licensee is responsible for the abuse, neglect, or abandonment of a child, or the abuse, neglect, exploitation of a vulnerable adult. That was the basis for the revocation. And you said the other stuff was relevant, perhaps for admission at the hearing, because obviously it came in, but they weren't charged. The nursing home a license holder was not charged with a separate violation of a separate statute that would support revocation. That was the charge. Is that true or false?
Your Honor, I believe that is actually false. Count 1 of the administrative complaint referenced not just violations of that specific provision, but also violations regarding the appellant's failure to provide appropriate care and supervision for residents. That would be violations of Rule 65G-2.012 of the Florida Administrative Code.
So the ALJ cited the wrong statute? Is that what you're saying?
If that is the only statute that the ALJ cited regarding count 1 of the administrative complaint, which I believe there were also references.
I mean, you said some generic language, and it seems to me you're saying, well, generically, if we allege this big net, we can use these little facts over here because generically they come under the heading of the big net. Is that I mean, am I hearing that right? Because it seems to me that, and they cited case law and you didn't dispute it, that's the basis for the revocation in this case. And if you don't have clear and convincing evidence and competent substantial evidence to support that allegation, you are not entitled to get a revocation.
And Your Honor, respectfully, I would refer to paragraph 38 of the recommended order, which acknowledges count 1 alleges that the activity described was a violation of Bridlewood by Bridlewood of sections 393.0673A, B, 393.123A.
Read the next sentence. Read the sentence that's got language in it that says what the APD must prove.
To prevail, APD must prove that Ms. Tomlinson, the licensee, was responsible for Mr. Saunders' action in some way, such as by providing inadequate supervision, providing inadequate training, or by not properly screening him before hiring.
In other words, they're responsible for the abuse because they did something wrong, and Mr. Saunders was able to capitalize on their failure.
That was the ALJ's position. Your Honor, I would respectfully disagree with that. As noted previously, both parties presented testimony and evidence regarding the appellant's actions immediately following the incident, as well as what sort of actions she took.
In paragraph 9 of the order, it says as follows. This is what the licensee did. Ms. Tomlinson told LW to close and lock the door. Now, this is before the licensee ever even saw the LW in person. This is all by phone. Ms. Tomlinson then told Mr. Saunders not to re-enter the facility. Then in quick succession, she called an APD representative, law enforcement, DCF, and LW's waiver support coordinator. Now, it just seems as though that's inconsistent with the notion that there's some sort of cover-up or attempt to persuade LW not to go forward. I mean, before they even meet, she's on the phone to DCF, law enforcement, et cetera, and you've already conceded that there's nothing they did leading up to, and your criticism is of after-the-fact conduct. I don't know. I'm just struggling to find out what more should have been done here.
And, Your Honor, I think the reason I would add some caveats to that is that those paragraphs, for example, paragraph 10 specifically states that Ms. Tomlinson arrived at the home about the same time as the law enforcement officers.
She's already on the phone to the police immediately saying, look, we've got a problem. Go on over there, right?
At which point, then the hearing officer, the administrative law judge, despite recognizing that she met with law enforcement officers, does not refer to exactly, basically how she helped them then investigate this incident. It says that, oh, she answered their questions. But when it comes down to the actual facts of what she did, the administrative law judge does not address the testimony of LW or Detective Napolitano that immediately upon their arrival, she started discrediting LW and saying that she makes things up, that she dresses provocatively. Does not address that when the case was to be reviewed by the assistant state attorney, which, as acknowledged by the assistant state attorney in the affidavit, which was introduced without objection, that was
wrap up.
Okay. My apologies.
I'll let you wrap up.
That was the sole basis for them dismissing the charges, was that LW did not want to press charges, and LW recognizes in her testimony that she did that based upon the instruction by the appellant. Based upon the facts of this case, Your Honors, and based upon the agency's proper following of the precedent in Marsaki, as well as the proper following of Section 120.571L Florida statutes, we believe that the appellant's license was appropriately revoked and that the agency's order should be affirmed.
All right.
Thank you.
Thank you. Mr. Woodring, you've got your 5 minutes left.
Thank you, Your Honor. If we look at the actual count 1 of the amended complaint, which is the only thing that's currently at issue here, because count 1 is the only one that remained, count 2 just went away. And I'll read it. It's short. It says, on or about July 11, 2010, LS, a direct care staff member employed by the respondent, engaged in sexual activity, including sexual intercourse with LW. LW is a vulnerable adult resident of the Bridlewood group home, which is owned and operated by the respondent. LS is a covered person pursuant to Section 393.135 Florida statutes and was responsible for providing care or support to LW on behalf of the respondent, one of the agency's providers. LS was acting in the course of his employment for the respondent at all times relevant to this complaint. A subsequent abuse investigation conducted by the Department of Children and Families was closed with verified findings of sexual abuse on the part of respondent's employee. The aforementioned incident constitutes violations of sections, and then it goes through and lists.
So I mean, basically using some of the broader language like care and support of LW, that can't be used in a broader context to say the aftermath or the so-called alleged cover-up would be sufficient activity that didn't look out for the care and support of LW to justify revocation. That, because in the context of your reading, that count was based exclusively on what happened prior to the abuse.
Yes, Your Honor. Well, our position is that that's the count in the administrative complaint, and that's what they're limited to. I mean, it's got to be clear and convincing evidence. And
had they wanted to seek revocation based upon the aftermath cover-up, so to speak, would there have been a statutory provision that would have supported that?
I think they
I don't
could
want to put you on the spot.
No, I understand.
Let's just say yes, there was. And if there wasn't that required to be in the complaint?
The answer to that is yes, but I think our posture would be let's assume they alleged that in the complaint. Again, remember, this is looking at the ALJ's recommended order. So even if they had alleged that in the complaint, and knowing what we know in the record as far as the activities after the fact, which is LW saying something, then you have Ms. Tomlinson denying that she ever said, you shouldn't report this, shouldn't pursue this. And I was willing to provide opposing counsel that portion in the record, but if you look at that page in the record, he's wrong. The question that's being asked is not a general question. The question that's being asked is explicitly what we read, which is, did you tell her not to do this? And she says, no, I didn't do that, wasn't going to do that. So even assuming, and that wasn't in the complaint, assuming that wasn't the complaint, if the ALJ was presented with what you could argue is conflicting evidence on that point, the ALJ could still have done a recommended order saying there's no basis to revoke, and that would have had to have been affirmed on appeal. Now, we're 5 steps removed from what was actually in the complaint, what was being done here. So I would just, and again, it's an unfortunate situation.
What about their position that, well, this all got tried, it all came in, but they knew we were going to come up with this information and there was no objection and they were prepared for it. Does that change anything?
I don't think that changes anything. I mean, there's often flexibility at trial or at a hearing to let many things in. But then it's the question of, what's the basis for the decision? And in this case, you had an ALJ who went through everything, who looked at everything, who had in front of him this complaint. So the mere fact, in other words, so what would the answer be? And, in an administrative hearing, you can let in things more broadly, because you can let in hearsay, it can't be the only basis, all this. So if you had the other standard, then as trial counsel, you would have to be absolutely everything that, you would object to, except if it was directly here. Typically, that's not the way. Usually, you will let things in, you do your proposed recommended orders, say this is relevant, this is not relevant. The mere fact that evidence comes in that's not relevant to the issues in the case shouldn't change the outcome of it. So respectfully, we would just say that, again, let's not forget the standard. The administrative law judge did a recommended order. They have to abide by that recommended order unless there's not competent substantial evidence to support it.
And you're down to about a half a minute.
Thank you. There clearly was competent substantial evidence to support it. They've attempted to do everything they can to say, well, somebody wasn't competent to evaluate, there wasn't this, there wasn't that. Bottom line, they didn't like the result, and they violated the law, and it's hurt a lot of lives at this point. I would respectfully request that you reverse their order. Thank you.
All right, gentlemen, thank you for coming. Well argued.
Thank you.
We're going to move on to number 2. Let's come forward for MTGLQ, Investors LP versus Encore et al.